back.
Woo! It's been something.
What's up, Tube? How you feeling, everybody? Keenan.
Already?
Yes.
Keenan already?
I like those frames, Carly. Miss Pretty in Pink over there, the producer.
Was somebody over there?
Hmm.
I'm gonna leave y'all hot.
Okay.
Cause I didn't.
That's right. My cash.
I don't see a shit. I don't see a shit. I know him.
Yeah. Good morning, folks. We're back. We're live. We're in the studio. Welcome back, my YouTube family. We got a great show for you today. So sit back, relax. If you've got some legal issues or questions, today's the day to pose them to me. 215-227-2727, the number for all things legal in Philly. Hey, we're live on 100.3 WRNB.
And Classics 1079.
Welcome back.
Thank you so much, Manny Manuel.
Happy New Year, sir.
And the same to you, and the same to you, and the same to all of our listeners. Yes, yes, indeed. If you have a chance to watch us on YouTube live, hang out, sit back. We're broadcasting as you speak. You can find us by going to the My Philly Lawyer website, clicking on Court Radio, and hitting the YouTube Court Radio button. That'll get you here. We're trying to build our YouTube audience, so like and subscribe. Or you can watch it on multiple devices simultaneously to fool them and make them think more people are watching than really are. How's that?
Is that the way that works?
Listen.
That's not. Was that fraud? That's not fraud.
No, it's not fraud.
Remember the days of having a pager and a beeper and a SkyTel and had to call an operator and had to text it? And
it is so funny that you mentioned this because I just had a birthday.
Stop.
Happy birthday.
Thank you.
Happy
Thank you.
birthday.
That little voice is David Langsam, who I'll introduce in a moment. But I had a birthday 2 days ago. January 8th is my birthday. If folks want to send gifts, that's fine. You can send it down to 1500 JFK Boulevard, Suite 1410.
No Cash App, no Zelle, no GoFundMe. Nothing.
But I was thinking, on my birthday, as I'm looking in the mirror and thinking, damn, you look a lot like your father. I was thinking there are jobs that no longer exist. Do you remember when you were a kid and you'd go to the movie theater and there would be ushers?
Oh, yeah.
To
They really
seat
were.
you.
Take
Yeah.
you to your seat.
Yeah.
With a flashlight.
Yes. Yeah, that was cool. How about if you were in a really fancy building, you'd have an elevator man.
An elevator operator.
Yeah.
Yep.
With that little round seat, and they'd go pushing buttons and closing doors and
Because
stuff.
God forbid you yourself should start pushing buttons.
Yeah.
We had that. That was a real job.
It was.
Yeah.
Do you remember when we had toll operators on
Everyone
highways?
remembers that. Toll booth. I wanted to be one. I thought it was the coolest job, standing there all day.
Yeah.
And collect money. Then roll out.
I wanted to be a long haul truck driver.
Is that right?
Yeah. Just to see the country and just to hang out with peeps and
I got a cousin that does that.
yeah,
He
that
loves it.
sounds
Great
like
life.
it does sound like fun, and they make good money.
Yeah. Oh, yeah.
Well, anyway,
What else doesn't exist?
Well,
Horn and Hardits.
I would go every Sunday. My grandpop and my grandma will pick me up from my mom's house,
Right.
my parents' house, and take me up after dinner to Horn and Hardit's for a piece of cherry pie and vanilla ice cream.
Coolest thing, being in a little glass.
Yeah.
Slide it. It was the coolest thing when you were a kid, right?
Yeah, Large and Cotman. That was our
was your
Horn,
street.
Yeah, that was Horn and Hardit's.
Horn and Hardits, that's where it was.
Yeah, Large and Cotman. Yeah, it was crazy. You know what's not going to be around soon?
What's that, Mr. Nostalgia?
Taxi drivers and Uber drivers.
What do you mean?
We're going to have automatic cars.
Waymo.
That didn't
Yeah.
happen. I can't Waymo, not yet. No,
Okay, well, the day is going to
no.
come when you're not going to have a choice.
It's got to be a choice.
I'm wondering, can I represent a car if it's involved in an accident?
Who are you suing?
Pain and suffering for the robot of the car. No, I don't think so. I mean,
how's that going to affect your life? Think about it.
Well, probably I'm going to be done this game by then, but it's going to be a whole lot less motor vehicle accidents. Not that there won't be any, because those cars will make mistakes, and there will be, as a result of that, probably product liability claims. Okay, you'll be suing the company for a defect to their software, to their product, to the mechanics of it. In some way, there will be a claim for the humans who are injured, not the car.
I just see this giving up a form of freedom. I want to drive, man.
Yeah.
Don't you? Look at you.
Of course, from the time I was 15 and a half, and I was licking my lips to get behind the wheel of a car.
That's right.
Yeah. I took my dad's, what was it? It was a Grand Marquis. It was this gigantic powder blue with a white vinyl soft top.
Like a ship, like a boat.
And with big old wings.
And you passed it in that big thing.
Yeah, I had to make a 3-point turn.
We all did.
Yeah.
Did you go to Belmont Avenue, or did you come a step you're in on the OC?
I was up in the place in Bucks County.
Bucks County?
Yeah. Near Neshaminy Mall.
Just for the driver's test, huh?
Yes, sir.
Okay.
Yes, sir. There was a, I don't know if it's still there.
Real fast, when do you see this coming, the automated cars? It's the massive takeover.
In certain markets, it's happening already.
No, but when do you see the point where, okay, this is it?
I don't know. Let me introduce
Please.
The young and smart David Langsam. Good morning.
It's all a facade.
The future.
Good morning. Good morning.
David used to be a law clerk at the old My Philly Lawyer Group. You know, you might recognize his last name because his old man is my partner. Mm-hmm. And David struck out on his own. He's a co-founder and managing partner. He took this from me, probably. Injury Law Partners. Nobody uses like Humpty, Dumpty, and Stumpty. They're all going for brands now. Who do you think started brands? My Philly Lawyer was the first legal brand in Philadelphia and in the country. Okay. In the country, I did it. Now they're all doing it. They're all right.
Great
anyway,
minds think alike.
Yeah. All right, Langsam. How's things been at the new firm?
It's a wonderful thing.
Are you building it?
Yeah, we're building it up. We're taking care of business. We're helping more and more people, and we need more and more people to go ahead and achieve that goal. So
I've even sent David some claims and cases, and he's handled them very professionally.
Construction type?
It was a tree case that comes to my mind. It may not be the only one, but it was a tree case, a branch that fell down and went right through the front windshield of our client's car. And David got an arborist, and he got experts out there to figure out how long that tree had been dead and dying. And yeah, he's a talented kid. So anyway, welcome to Court Radio. It's not your first time, but
it is not. But it's always a pleasure. Thank you for having me.
Pleasure's ours, David. Thanks.
Yeah. So we're talking about Uber cars and products liability. Do you see that? Is that the future?
It's already happening.
And when do you think it's going to roll out on a more massive basis?
Well, I think it depends on where you are. So if you go out west in California, it's a much more prevalent thing, and I have a sneaking suspicion that we're going to see it a hell of a lot more out here on the East Coast. And in fact, if you look already in our area, if you're driving around Center City, you may see some of these Waymos. They're testing them out, so there may be drivers that are actually behind the wheel, but they're
sometimes in the passenger seat. And they have like a set of controls over there if they have to take over at the last second. Yeah. But you're looking and you're like, well, there's no driver in that car.
Do I have to sit in the back?
You can sit wherever you want. You're going to walk in the car and they're going to say, good afternoon,
You've done
Mr.
this
Glenn.
You've done this already.
No, but I've heard stories.
Good about San Francisco?
Good afternoon, Mr. Glenn.
Okay.
We're taking you to, 2763 Stenton Avenue. Mm-hmm. Have a seat and relax.
Right.
Yeah. I wonder if you could say, like, hey, can you stop? I need, like, a cigar, and it, like, finds the nearest cigar store and pulls in and...
I'm sure I could find anything.
Yeah.
Find anything for
I think it's point A to point B, isn't it? No, hold on for a second. Mike, can we stop here? I don't think you can do that.
I don't know. Well, that might be the future.
Could be.
Yeah.
Could be.
You can make a stop off.
I mean, just like on a ride share, you can put it on the app and it'll update
Stop along the way.
Yeah. Some R2D2 voice. Sir, it is not advised that we stop at this time.
215-227-2727. You got legal issues. We need you to be jumping on the phone and giving us a call because our listeners are a part of this show. We could not do this without you. Your crazy questions sometimes entertain and delight us. So keep them coming. 215-227-2727. So what's going on? Like, what do you have a case or cases right now that you feel like you could talk about that are interesting for our listeners?
Oh, we got plenty of cases, I suppose, that we could talk about. I mean, we can address products. There's always a whole world of things to talk about in
tough
product
cases.
Liability land. Sure, they are tough cases because oftentimes you're not dealing with a store or a sidewalk or a driver that blew a red light. You're dealing with a multinational company that has infinity dollars and then lawyers out the wazoo, and they don't take particularly kindly when you say that something was designed dangerously, because if one's designed dangerously, then they're all designed dangerously.
We just got through the holidays, and I know that oftentimes little kids are getting injured by toys that are not designed well. And we at My Philly Lawyer just wrapped up a case that had been going on for a long time with these little cradles that your moms would put the babies in to rock them, and the cradles were designed defectively, causing the babies to suffocate. Yeah. So there are a lot of design defect problems that arise in the child or children arena. Have you seen any of those?
Yeah, sure. And that creates the strongest visceral reaction, because anytime that the victim, the injured person, is a child, obviously it creates that much more of an emotional response. So, yeah, oftentimes with kids, one of the bigger issues is the size of the product that's at issue. And if you have, for example, an art set, or you have something that has little small pieces that may break off, one of the problems that you oftentimes face is that a kid is more inclined to put it in his or her mouth. And if a kid puts a small piece from a toy in his or her mouth and chokes, then you got a serious problem. And that, to this day, I had a case involving a 5-year-old little girl that choked on a marker cap. And that is still the most powerful stories that I've come across in the time that I've been doing this.
Did she pass?
Yeah, she didn't make it.
Oh.
Yeah, I mean, when we're dealing with our more serious claims, those that involve, catastrophic injury, death, burns, there's really no amount of money that can compensate somebody for that loss. And, the civil justice system does its best, but it's wholly inadequate in those circumstances.
I remember when we were little, two things: the paint chips. Lead paint chips, little kids were eating those, and Legos.
Yeah.
The Lego things. I remember kids were putting those in there. I was a big concern about that.
Yeah, and listen, anytime that you have a product and a child and little pieces that may hurt them, the reality of the situation is you also have to have parents. You have to have supervisors. You have to have someone who's a guardian, otherwise keeping an eye out. And, one of the things that we see, actually, unfortunately, more often these days are incidents involving kids at schools and at daycares. And that implicates yet a whole other set of circumstances, because as a parent, you send your child out to somewhere where you fully expect them to be supervised and taken care of appropriately. And then when something happens bad in that type of environment, it is the worst of all worlds.
At daycares, is it accidents or is it abuse, more or less?
Unfortunately, it's both. And oftentimes daycares and schools have videos. Sometimes they're recorded, sometimes not. But when you have something that's captured on video and you see the caregiver being the abuser, aside from being unconscionable, that for sure is the type of claim that should be pursued, because that's not the type of thing we should expect to see.
What's the first thing a parent or parents should do if their child is injured using a product? What do you suggest the steps are for them to take?
Evidence preservation. It's always the first step, regardless of what it is. The set of circumstances, whether it's a product or someone getting hurt at school or someone getting hurt in any capacity at all, is making sure that the things that you're going to need, the stuff that you're going to need, the physical evidence, the videos, the statements, the photographs that you're going to need to be able to investigate and prove out a case have to be available for you to be able to do it.
Okay.
So what does that look like? Well, let's say that it's a situation in which someone gets hurt at a daycare or a school. Well, you get in touch with administration and you send them a written request, even if it's informally by email, save the video. I want to see the video. And we see that very often where when things happen at schools or daycares, you get a pushback. Administration doesn't want to turn it over for obvious reasons, but so long as you ask, it has to be saved.
And if they refuse to save it or they fail to save it, there are consequences to them for that. What are they?
Yeah, so if there's some evidence that exists and for whatever reason goes away and it should have been saved, and you file a lawsuit, litigate the case, you go to trial, then you may get what's called an adverse inference, which in application just means the judge says to a jury, oh, by the way, this thing existed. The person that was supposed to save it didn't save it, even though they should have. So you, jury, can believe that the reason why it was destroyed or not saved is because whatever it showed was really bad for the defense. And it's a pretty bad outcome, because even if it wasn't that bad, the fact that they didn't take steps to save the stuff really is a dangerous area for
they can't claim ignorance.
defense.
Well, I didn't know I was supposed to save this.
Well, they can, but that's why you got to button it up on the front end. So the question is, what's the first step? The first step is make sure that it is ironclad, no question. We asked for it, you were supposed to save it and put it away, and you didn't.
Okay.
You know, I don't want to jump off topic here,
Right.
okay, because it's a serious, we're talking about some legal issues that are important. But it comes to mind as I look at the YouTube faces, okay, that there are guys who wear their hats backwards. And then there are guys who wear their hats forward. I personally cannot wear a hat backwards.
Ever?
Gary, give
Never?
me your hat. Give me your hat. Give me your hat.
But you never, ever?
Never, ever.
Stop. As a kid, come
Never.
on, we all did it.
No, look how stupid this looks.
Well, take off the headphones first.
Oh,
That's
sorry.
stupid. Yeah. That works, Dean. No, Dean, that works. Are you serious?
No, I don't believe that. I don't have a face for a backwards hat.
Who told you this?
I just feel it. Let me see you. How about you? Come on.
Backwards?
Yeah, backwards.
Man, I've done backwards forever.
Yeah.
Yeah, you can do it.
You can do it too, D.
It looks good.
All right. I'll try it next time. But
Then we put another hat on you and you thought it didn't work. You said you thought you looked Amish or something.
What about a cowboy hat?
oh my God, no.
So no hat. So I've never seen. Now that I think about it, you've never worn a hat.
In theory, I like the idea of like I always when I'm on vacation or something, I'm in a store and I'm looking for something to buy because I'm like Jones and I haven't bought something in 10 minutes. I go to the hat store section and I try on the hats and they look good. And then I leave and I buy the hat and then I come home and I never wear it. Put it on a shelf and I'm like, that was a mistake. I'm not a hat guy. I don't know. I'm going to 2026. I'm trying to be a hat guy.
Is this a resolution?
Yeah, it's my resolution
You
this
are
year.
an interesting man. D.
Starting next week, I'm going to come in with a hat and I'm going to test it out.
You need to at least wear a Philly lawyer, my Philly court radio hat, right? Right?
Yeah, I do have a court radio hat.
Of course you do.
Yes.
All over the
Yeah.
I don't believe that.
In fact, the next person who calls in is going to get a court radio hat.
215. The phones are ringing off the hook now.
215-227-2727. Or if you post on YouTube, I'm going to send you a My Philly Lawyer hat. And there aren't a lot left. I have to find one in the hat closet because they're a rare item. They're very rare, very valuable, and very rare.
Well, one reason is because you spared no expense at the quality. They're not cheap hats. That's the first thing.
Well, I'll tell you, when I get, what's it called when you get
swag?
Swag. That's it. Thank you, David. I needed a guy who had a 30-something answer. Swag. Yes, that's it. Swag. I do not spare any expense.
I got to give you that. You know.
If I'm not going to be comfortable wearing it, I will not give it to my listeners.
Then why do you wear hats? Why do you give out hats?
Well, I didn't say
I'm messing with
I enjoyed, or I took the risk of wearing it, but it is a quality hat. If I choose to wear it, nobody's going to say, "Oh, that's a cheap." You're not going to find a hat that I have with that plastic clip on the back with the little buttons on it.
I feel you.
That's
Yours
yeah.
do have the clasp. I have
Yeah,
to give you
a
that.
clasp or
they're fitted.
Velcro with the material. They're not junk. I'm not.
It's from a guy that doesn't wear hats.
Yeah, but I know what good is. I might not know, I might not want it, but I know what good is.
You travel, don't you?
Not enough. That's another resolution for 26 is for me to get out of town more often.
One of the dead giveaways for Americans is we always wear hats everywhere we go. Baseball hats. Foreigners say, yeah, we can always spot the Americans. Y'all, baseball,
really?
Absolutely.
Yeah. Well, then
backwards, forwards, everything.
I can sneak in.
Yeah, you'll fit right in.
I'll fit
You're
right
hat
in.
list.
Yeah.
One of my favorite things to do when not in the Philadelphia area is wear an Eagles hat.
Like in
Eagles
other
gear generally. And
Yeah, see, he
Agitator.
Yeah, he's an agitator.
but I'm an avid Hatsman also. So that just works.
Okay.
Well, we went way off topic, did we not?
We did.
They
We
wear
did.
hats on construction sites. A lot of are people who getting hit with trees
Hard
wearing
hats.
Are they wearing hard hats?
Yeah. Okay.
Back on track.
You started in this business doing construction accident cases.
Yep.
We won't talk about the firm that you were there with, but they did a lot of construction work. They were cozying up to the unions.
Yep.
Yeah. What's the most common accident you see on a construction site?
Well, I'd say injuries associated with falling from height, either things falling onto people from height or people falling from height when they're not otherwise secured. So, obviously, each job site is its own animal and it's got its own trade work that's going on, which requires its own level of precaution. But probably the most common thing that we see, and this is still something that's squarely in our wheelhouse. So, we do a lot of construction site accident work, and if you're working from height or you're building things at elevation, you got to make sure that stuff is secured.
There you go.
Any window washer accidents?
I don't know that I've seen a window washer accident, but I'd imagine, given the way that they're working from height and the way that things need to be secured, especially if they're descending down the side of a building, that you got to make sure that things are appropriately anchored. That's actually similar to the way that roofing needs to be done. You see people on roofs all the time, and they're walking around, but they're not actually tethered to anything. So God forbid somebody loses his or her footing and comes over the side of a roof. Well, you're supposed to be tied off. You're supposed to have a lanyard and be tethered into it.
Now, here's the interesting thing about this whole area, and construction workers that are listening will understand. Usually, as my listeners know, when you're injured at work, you have a workers' compensation claim. You can collect, thank you, Manny, you can collect your wages if you're unable to do your normal occupational duties, and you can collect your medical expenses that you are required to engage in with a doctor in order to get better. But what you cannot do is collect for pain and suffering from your employer. The workers' comp system has forced you to give up that claim in exchange for having a fairly easy time to collect your wages and the medical expenses. Yet, you guys always find a way to get around that. How is that, and why? I mean, are you tricking the system?
It's got to dig a little bit deeper. It's all about being creative. But no, Dean, that is one of the fundamental things that we run into all the time is, you can't sue your employer. You get comp. So what you have to do is try to find whether there was someone else involved in whatever the issue is, whatever the operation was, that may have did something that caused or contributed to the bad outcome.
Well, let's talk about your roofing idea. A building is being built, and there are roofers who are laying a roof down. There's carpenters, there's plumbers, electricians. Under those circumstances, could you foresee a culpable party, and who is it and why?
Yeah, sure. So obviously there's a host of different projects, but we have a residential project or a commercial project, and obviously the scale of the project will oftentimes inform who may be involved. So you may have a property owner, you may have a developer, you may have a general contractor, you may have a site supervisor, you may have a standalone project manager, and then a whole array of different trades on site. And if the person that got hurt is a W-2 employee of Roofing Contractor, Inc., but then there is a general contractor that has some site supervision responsibility. That oftentimes is something that we're going to look at. What did the GC do or not do that caused or contributed to what happened? And whether it's roofing or, chemical burns, anything that happens on a job site where there's a general contractor involved is oftentimes one where there is at least an opportunity to investigate a viable claim against someone that isn't the injured person's W-2 employer.
Your brother is a builder.
Yeah, that's true.
And
a hatsman.
Would you sue him?
I don't think so.
Come on, Dave's business, David. It's nothing personal. Nothing personal.
You see, that's the difference between somebody with ethics. Because I'd sue my mother. Oh yes, I'd bring her right back from wherever she is, and I would say, hey, you messed it. No offense. I'm not. It's not personal,
Just
but
insurance.
it's I got to go. David, on the other hand, no, his immediate response, no, of course not. I wouldn't sue my brother.
Every holiday that would come up, it would start a.
Yeah, well.
Remember that time you sued your mother?
But I'd probably be driving like a new Lambo with the money I got from her.
Would you break her off a couple of dollars?
I'd give her a ride in the Lambo. That's about as far as it'd go. 215-227-2727. We're talking with David Langsam. Let's get a caller on the phone, Eric. Line 1, we got Joseph. Welcome to Court Radio, Joseph. Good morning.
Good morning, Dean and company, and Happy New Year. So this might appear as a lame question, but I was really interested in your take, as well as with Manuel and Tactics, in terms of electric vehicles. And so I just happened to be seeing a story, a news story in regard to, I believe, so I stand to be corrected, a Tesla car, Telsa, that had been to this date involved with 15 fatal crashes, all with no drivers. And the one that stuck out the most was one in which the circuitry of the car just shut down while the two passengers were in the car, and it ended up being a fiery collision. But my thought is, based on your positioning, is that this sounds to me something like the future where you see those signs, enter at your own risk, so that any liability would appear to be almost nil, because you're entering something that inevitably something might happen. So therefore, what's the use of even suing? Because it reminds me of what you always say about SEPTA capping their accident.
Okay. All right. Well, listen, number one, you, Joseph, don't ever worry about asking a foolish question, because they're never foolish, and they always spur us to think about really important things. So that's number one. Number two, it's Tesla, not Telsa, and put that S first, because I want you to get it right when we sue them. When we sue them, and we do, and we will, we got to get their name right. Thirdly, I don't know that that a company can wave away their responsibility.
Yeah, when you enter the car, you already agreed to a certain disclaimer,
haven't you?
Or disclaimer.
Yeah, in the terms of service. Okay, it's not going to be necessarily a sign on the door, but when you deal with an app and you schedule a pickup, you have signed off on terms of service, or TOS. That is this long, complicated document, and it tells you can't sue us, and if you do, you have to do it in some court in Texas, in the county where everybody hates plaintiffs, right? So do those terms of service prevent a lawsuit under the circumstances that Joseph raises, where you're injured because of a product or car, and you're injured due to the negligence of the manufacturer or somebody along the chain? Do those terms of service keep you out of court?
I think it depends. So I want to address it in a couple of different contexts. So negligence isn't something that I think would necessarily apply. If we're talking about Teslas and Teslas being self-driving, I mean, that litigation's already happening. It's already existing. And the focus there isn't about whether somebody made a decision to get into a self-driving car. It's about what the manufacturer did in designing and testing that car. That is a strict product liability claim. That isn't going to be something that
All right, I want you to
applies negligence concepts.
We can't just throw that out there. When we come back, and we're going to take a quick break, there is a huge difference between a negligence claim and a strict products liability claim, and you have to stay tuned to listen what that is. Be right back in 2 minutes. We are still on YouTube
David.
Live, so no
People are asking you
farting,
questions.
no bad words, no nothing. You got to.
Good work, Carly. People are asking you questions.
People are asking me questions. Well, I don't know what they are. What are they?
Who does Dave work for again? Does he work for you, and why not?
Dave,
That's what they said.
That was 20 years ago? More than 20.
More than 20
I'm
years.
40. I just turned 40.
Okay,
So-
yeah. David worked for me as a
More than-
student. And then did you work after you graduated for a while?
No.
No. Went
No.
from being a student worker, graduated, went to work at another law firm that had a different focus of the practice where he wanted to get some more experience in that area. And then went from there to opening his own shop. And so he's now with a place called Injury Law Partners. And but we work together on cases, and David's practice is growing. And what's your partner's name?
Ben Bear.
Ben Bear. And
Yeah.
Ben Bear's father was Supreme Court Justice Max Bear.
Yeah, he was the Chief Justice for a bit of time and then unfortunately passed away unexpectedly in 2022. But before that, he was actually on the bench in Allegheny County out in Pittsburgh. So a lot of what we do, in addition to a robust Philadelphia practice, is a lot of Pittsburgh work.
Right, right.
Yeah.
Because Ben has contacts
Yep.
in Pittsburgh, and they're developing those. So that's kind of David's history of where he was, where he is, and where he's going. But good question from the YouTube audience. Anything else, Carly?
Well, they responded saying that David looks 20 years old and not 40 years old.
Yeah,
I'll
and-
take it.
Yeah,
Keep
yeah.
it coming.
I remember.
And I got 3 kids.
I remember
Good
when
city-
David
good
was
city living.
born. I remember when David was born, and so yeah, that's horrible. Jesus.
I thought that was a good day.
Yeah. Damn. Yes.
For this hour, I work for you.
Yes.
So if anything happens to me, anything falls
You
on me,
can't sue me.
I sue you.
You
right?
can't sue
I didn't
me.
sign anything.
You workers' comp. I have workers' comp for you, my brother.
That's true.
Yeah.
All right, we're
But you
going
could
hot.
sue the studio
But Dean, I
Be-
would never sue you.
because you're not working for the studio. So
Here
you
we go.
could sue them.
But did you hear me? I would never sue you, my
Fool.
friend.
Fool.
No, we could have. I'll break you off. That's the way it works.
Yeah, 40%.
Hey.
Are we back?
Yeah.
Oh, sorry.
I'm so sorry, radio audience. We did not realize that.
I'm ready to tackle ball.
215-227-2727. If you've got a legal issue, we've got the answer. Give us a call. We're here live and in the studio with my friend and colleague, David Langsam, who runs a shop called Injury Law Partners in Philly. He and his partner, Ben Bear, do personal injury litigation, construction site accidents, products liability, and things of that nature. And so I've been talking to David about injuries with products, like what happens. And Joe, who called in earlier, posed a question about whether you could bring a claim against somebody like Tesla if you have signed off on a term of service that has a clause in there that says, you can't sue us, or you got to sue us in an arbitration or something of that nature. And David was explaining that if he brought a products liability case, there's a big difference between negligence, which is anytime somebody does something which causes an injury, which they knew or should have known would cause an injury. You're making out a claim under general principles of negligence. But when a manufacturer designs and manufactures a product, they're held to a different standard. And what is that?
Strict product liability.
And how is that different from negligence? I have to show Manny Manuel knew or should have known that the product was defective, or that his actions could lead to an injury, and despite that, he didn't use reasonable precautions, and an injury occurred. How is those terms different than strict products liability?
So I guess I'm holding a water bottle, right? So let's use the water bottle as an example in the product liability claim. The focus isn't what I do with it. The focus isn't on whether or not I was reasonable with the water bottle, whether I cleaned it appropriately. The focus instead is, what did the manufacturer choose when it designed this water bottle with the particular materials that it chose when making it? So the analysis isn't on what any person did. Instead, the analysis is on what the manufacturer did and whether its design was defective and if the defect caused the bad outcome. Now,
so the manufacturer doesn't have to have realized that the product was defective or any such kind of analysis. If the product caused the injury and it's been determined to be defective
In the design.
or in the manufacturer,
or in the development of the warnings or instructions or labeling. There's a few different contexts.
Even the labeling.
And the labeling.
then the manufacturer is automatically responsible for every injury that flows from that defective product.
Yes. Now, the one thing just to point out is it is different than absolute liability. It is not an automatic jury verdict in favor of the injured person, because the manufacturer can still put on a defense. And one of the defenses may be that you, injured person, misused the product. Use the water bottle again as an example. Well, it's not because we designed it with the wrong material or the wrong clasp and it fell and it hurt somebody. It's you didn't maintain it appropriately. Now, they can make the argument and they can try to offset their responsibility by pointing at the injured person or somebody else. But at the end of the day, philosophically, the approach in a product claim is whether the product is defective and whether it caused an outcome.
What's that made out of, roughly?
So, metal.
All right, so I use that not to drink, but I take a nail and I'm doing this and I get hurt.
Yep.
I'm using it the wrong way. If I got hurt, it's my fault.
Yes.
That's what you're talking about.
So, if you were to go ahead and you were to bring a claim against Thermo Flask, the water bottle manufacturer, and you say, I got hurt because I was chipping away at it with a hammer and a paint chip from the bottle hit me in the eye.
Right.
I say, all right, so what's the intent? What is this thing supposed to do? It holds water, keeps it cold, and you drink out of it. What you're not supposed to do is beat it with a hammer, because then you misused it, and the paint chip that flew off of it and hit you in the eye is a result of you doing something wrong.
Right.
There you go. 215-227-2727, the number for all things legal in Philly. If you've got a legal issue or question, whether it's on topic or not, please give us a call at 215-227-2727. We will answer. I just got my first bank shot for 26.
Got it in?
Oh, of course.
All right.
You know, he's at home in his office every day. Every day.
Practice.
Every day.
How about them Eagles?
Let's go Birds.
Hey.
They going to win this week?
Yep.
Certainly hope so.
They're going to cover is the more important
I know,
question.
that's the
because
What's the line now?
What is the line? What is the line?
5.5, 6.
5.5.
Yeah.
Okay.
Yeah.
Tactic, 5.5, 6.
They covering?
I'll take it.
Yeah.
Okay.
He would take it. Okay.
I'll take it.
I took Indiana last night and the over. Big night. Big night.
Oh.
Yeah.
How you feeling?
I'm feeling 5 digits richer.
My man.
Yeah. Yeah.
Hey, you thought the Sixers doing really well? You following the boys?
I do not. I haven't followed them since Allen Iverson left the team.
Oh, come on.
It's been a few years.
Boy.
True that. I used to have season tickets right under the basket, and when they were in the Spectrum.
Oh, boy. That you really are going back.
Yeah.
Yeah.
Those were the days.
I'm trying to find, David, a photo. There's a tree in my neighborhood during that storm we had a couple of weeks ago. Fell on top of a car. That tree stayed on top of that car for days. Here it is.
Well, too bad the
But
YouTube
there
audience
was
can't
no
see it.
damage to the vehicle at all. Do you see any damage? That tree stayed there for days. And then they took it off, and that car looked unmarked.
You know what? I don't know if it was intended to be a dovetail with product liability, but Nissan, it looks like that's a Nissan. They should put that in an ad.
I thought the same thing. Dead tree, big dead. You saw a big dead tree fell in that car. Look at it.
I think it was
scratched.
I think it was Toyota. They had an ad years ago, and I think it was a scorned girlfriend or boyfriend was pushing a Tacoma over a cliff just to say, I'm going to show you. I'm gonna destroy.
Wow.
And the whole essence of the ad was that the truck survived the couple 100-foot fall unscathed and ended up on its four wheels and then just drove off.
Do you see these a lot?
Let me ask you, that brings up an important point that I wanted to raise with David because he and I had that tree case. What is the current state of law for property owners and their trees?
Yeah, so...
Is it their trees?
Well, that's a question. Who owns the tree? But let's start with assuming they own the tree. What is it that we as property owners have to do with our trees?
So as anything else, right, whether it's a sidewalk or anything that somebody owns where there's going to be folks either on their ground or nearby, you just got to take appropriate steps to make sure that it's not going to needlessly endanger other people. So in the context of trees, everyone looks at them and they're beautiful and they're important, but you also have to make sure you maintain them in the same way that you would maintain a sidewalk. And the reality is it's expensive. I understand it. You have to get a certified arborist to come out and look at your trees, but the level of obligation in large part depends on the type of property that you're talking about. So just as an example, like an institutional or commercial property owner, a golf course is going to have hundreds of trees because that's an important part of the ambiance, but they're going to have departments specifically geared toward making sure that those are all okay and structurally sound. A property owner, especially one that has a residential property or any type of property near a road, has to take special steps to make sure that trees aren't going to come down and cause bad outcomes.
Okay.
And as riveting as tree law may be, they're actually...
Is that a thing?
There is. Oh, it's a thing. It's a thing.
Tree law.
Yeah. A couple of months ago, I actually gave a seminar on tree law.
That's hilarious.
Yeah.
I'm studying tree law. Tree law. Not
Yeah.
pre-law. Tree law.
Tree law. And the bad outcomes are bad because trees are really big and really heavy. And when they come down, that's unexpected. And people just find themselves at the wrong place at the wrong time. But specifically about properties near roadways, when a tree comes down on a road, bad things happen. Obviously, that's one of those cases that we have together.
It is, and I, as a property owner, recently in the last 12 or 18 months, I had somebody come out to the house, and we went through the backyard, and anything that looked like it was dead or dying, we took down or took most of it down, enough of it down that it no longer posed a problem. Because if I had people in the backyard and a big old tree branch comes down and squashes you, then I would feel horrible, and I would also be responsible, and my insurance company would have to pay many hundreds of thousands or millions of dollars out. So I spent, it's not cheap. I think I spent $3,000 or $4,000 for them to come through and to clean it all up. Folks who don't do that are leaving themselves open to liability, and their homeowner's insurance company would be responsible. I want to caution people that people call me a lot of times because their car was hit by a tree while it was parked and unattended. Their fence was knocked down by a tree from their neighboring property. And they say, can you bring a claim? And the answer is yes, but I'm not going to. Because we don't represent cars or fences. We represent people who sustain bodily injuries.
That sounds like a bit. We represent people.
Yes.
The way you just said that. That was
okay. Well, it's a truth, and so when you have a property damage only claim, those are the claims, as I've often schooled my listeners, to take on yourself and to bring a small claims complaint in your local, district justice or down in the municipal court and prosecute it on your own, because it would cost you far more to have an attorney prosecute that claim than it's worth.
Well, how many times have we heard the story of the neighbor complaining that your tree is leaning over my fence and my property? And
And now here's a
It makes for
question. I don't
good
know if you have.
TV.
I don't know if I don't know if you have the answer, but I'm going to ask it anyway.
Lay it on me.
A tree branch is extending over the neighbor's property. Does the neighbor have the right, if it's dying or
Or
dead,
the apples are falling on
to
their property.
cut that branch off at the property line?
Yeah, so if there's a portion of it that's crossing over, then sure, if it's going to endanger your property, your house, your family, people that may be at your place, then yeah, you can. But it also may be that it's really more of like a relationship management issue, unfortunately. So you have a neighbor, you say to the neighbor, take care of your tree, it's causing all these issues for me, and the neighbor ignores you or they say no, just document it. Right? The unfortunate reality is, under those circumstances, you may just have to document it, and then, God forbid, something bad happens. You pull out the letter, the email, the text message, and say, I told you. Now this is all on you.
All right, so wait. Are you saying, though, document it, but you can still go ahead and cut the branch?
That crosses over your side, sure.
But document it first.
Oh, yeah.
But you have the right to cut the branch. Everyone hears that part.
Yeah,
Okay.
the idea would be, let's figure out a solution together, and sometimes you can't.
Let's talk to Jackie on line 1. Good morning, Jackie. Welcome to Court
she
Radio.
Oh, Jackie.
Somebody else.
Yeah. Okay, we can go to somebody else. How about Amanda on line 5? Oh, Amanda.
Hey, Amanda.
Hi.
Hi.
Good morning.
Hi, good morning,
Good morning.
Amanda.
Hello.
What's up?
So I was calling because through Philadelphia they put up these speed bumps, and I drive a Honda Civic, which sits very low. So going over these speed bumps, it ruined the undercarriage. I replaced it one time. So my question is, am I able to sue the city?
Wow, I hate those speed
This
bumps.
is a big deal right now.
Yeah. I mean,
Sleeping policeman.
yeah. We had a whole show on sleeping policemen.
It's a big issue right now.
Yeah, they're popping up more and more everywhere.
Mhm. And at different heights.
Yeah.
Yeah. It's like there's no set level for these things.
Well, I think that's probably what the issue is.
Yeah, uniformity and having it at a height that doesn't damage one's car is an important part of putting them in. I would say if the city of Philadelphia has speed bumps that are so high that you cannot get over it with your car without damaging your car, you're beginning to make a claim for a property damage claim against the city. Like they can put these things, and they have an overriding interest in safety. And so the point is they're putting these there to make it safer for pedestrians on the road and bicyclists and things like that. They have a good argument, but they have to do it in a manner in which it doesn't damage your car. Your car is also legally entitled to be on that roadway driving down the street. And if you can't get over that speed bump, now, if you're going over the speed bump at 30 miles an hour and you're damaging your car,
That's different.
But
or is it?
It is. It is.
What if the speed limit is 30?
Well, then I would say, yeah.
I'm thinking you can damage it if you're going under the limit.
You could, and that's where I think if she can testify that she was going, let's say,
25.
10 miles, 15 miles, 20 miles an hour over the speed bump, and it damaged her car, I think she can bring a claim against the city for defective roadway.
You haven't gotten any of these types of cases.
No, because again, what are we talking about? Remember the preface.
Right.
I'm not representing your car. Okay, so as much as I like Amanda, her undercarriage does not rise to the level of needing the talent of my Philly lawyer.
That was pretty good.
Yeah,
Her
yeah.
undercarriage does not rise to the level.
Amanda, I hope I answered your question. If you want to bring a claim against the city, you should go to municipal court, gather up your documents, and sue them. Sue Mayor Parker and her team. What was that, Amanda?
You said go to municipal court?
Yeah, that's where you're going to want to. For any claim under $12,000, you can sue the at-fault party in municipal court.
Okay, thank you so much.
Have a great day.
You keep. Uniformity is the key here.
I got to take a break, uniformity. Folks, we'll be back in 2 minutes, but if you got calls, give us a call. Hey, YouTube.
Hey, guys. We started talking about Waymo, and
Yeah.
they're all electric, aren't they? They all are.
Yeah.
Okay. And right now, they, for the most part, here are manned by somebody.
Because they're just tested, they're geomapping for the moment.
Right. But when we start using them, that's it. No one. It'll just be
Yes.
and
You're just going to get in the car.
and the car knows when to accelerate, decelerate, and drop you off. And I'm not feeling it, man. I'm not going to be amongst that.
Come on, bro.
Great, bro.
Listen, you don't understand the opportunity that's there for you and I. Come on. What the hell? Come on. Come on. I could.
In perpetuity?
Oh,
what are you
listen,
trying to tell me?
Don't you want to be the lead plaintiff against
The
Waymo?
first Waymo guy.
Yeah.
Wow.
You and me put our suits on. We're walking into court suing Waymo.
Wait, I'm suing. Why am I walking in the court? I
Yeah.
am injured, right?
Yeah. Of course you're going to be
I'm
injured.
wheeling the court.
Go limp in the court.
Yeah.
in the court.
We do have a question. They said in Philly, the trees by the curbs, are they owned by who? If it's like on a curb.
The property owner, the city may have planted them
They
back
do.
in the day, but the property owner has a duty to maintain them.
All the way up to the curb.
Right now on my
Now
block.
the city has joint responsibility. So if let's say a root of a tree pushes up the sidewalk and you trip, I'm going to sue the property owner and I'm going to sue the city of Philadelphia. Both of them have responsibility, and one would be primary property owner. City would be secondarily responsible. But if your injuries are significant enough, I'm suing everyone. Do you understand me?
And maybe PennDOT.
PennDOT as well. And maybe the adjacent property owner, and maybe, who knows, maybe even God. Not beyond me. Okay, for our YouTube audience, next week we have criminal defense attorney Kenny Edelin coming in.
The Omega Man.
Yeah, he is Omega Sci-Fi. Yeah. Look at this, like this. Like
Don't do it.
Don't.
I will get myself in trouble.
Man, listen.
Yeah, baby, we're back. And live in the studio audience with David Langsam.
Hey, good morning.
We've gotten some great calls. We've got Sabrina on line 3, I believe, Tactics. Do we? I don't know.
Do we cheat him and how?
Line 3, Sabrina? She gave up on us. I don't know. The lines are all lit up, and I don't have pieces of paper from Sarah. And, yeah, I missed.
What's the shooting percentage?
Yeah,
today?
what is the shooting? I give it,
66.
I was going to give it higher than that. But all right.
Today, well, it was 3 shots. I made 2.
How about for the season?
Well, the season just began. Yeah.
How'd you
just started.
finish last season if you had to give yourself a percentage?
75 at least.
Okay.
Yeah, at least 75%. Okay, we have any questions? But I don't want to leave our YouTube audience out. Any questions from the YouTube audience?
Well, Keenan just said, Dean, you're my type of guy. You're ruthlessly aggressive.
Yeah, I guess so. It's kind of it's the way I was.
Ruthlessly
Yeah,
aggressive.
I don't know. I'll take it.
Dave, is that the way to be in these days in these rooms? You got to be ruthlessly aggressive.
Sure.
Is it not case by case? It's every case.
I mean, you got to be ruthless in the sense that you're going to keep on digging.
Okay.
Keep on digging. Be the net. I don't mind being the net.
Nah.
Nah. The whole job, well, not the whole job, but a lot of the job is getting people to do things they don't want to do.
If you don't mind, Dean, did you always want to do law when you were young? You kind of grew up in the family.
Yes, he did.
I was preordained.
Yes.
Was it?
I'm the youngest of 3 boys, and
He had a little-
by default,
he had a little-
someone had to be the lawyer.
A little mallet. He had a little mallet when he was a kid.
Order.
Yeah.
I think it suits me well.
Yeah.
Okay.
Okay. And we got line 2, Earl. Earl, welcome to Core Radio.
Hey, Earl.
Hello, how you doing today?
I'm
right.
well, thank you. What's your question or comment?
Okay, I had cataract surgery. The right eye went fine. The left eye, something went wrong in the surgery, in the procedure. Surgery usually takes 20 minutes. I was in the operating room for over an hour. Then I got discharged, and I had a lot of pain in my eye when I was discharged. All night, I didn't sleep.
How long ago, Earl? Earl, how long ago?
About 3 months ago.
Okay, and has the pain abated? Are you okay now, or what's your current condition?
Okay, I went to the doctor that operated on me. I was still in pain. She said, go to Will's Eye. They'll take care of it. I went to Will's Eye. They did relieve the pressure on the eye. So in like 4 or 5 days, another surgeon operated. He fixed everything. But when I came out of it, I had less vision in my left eye than I did before when I went in.
Okay. So hold on, Earl. Hold on. Let me jump in here because we're going to run out of time, and I want to just kind of set the table here. When you have a potential medical malpractice claim, or in this case, possibly medical malpractice and products liability. Why, I say? Yeah. Because when they put a new lens in your eye after cataract surgery, maybe the lens is defective and it scratches your cornea or something. So I could envision where this could be either medical malpractice, products liability, or a combination of both. But when you have that claim, you need experts. So what Earl hasn't said, he said something went wrong, but that's his kind of seat of the pants. I'm from Philly, and one went right and one didn't, so something must have gone wrong. You cannot make that jump, that leap, as a lay person. Okay, I can't make that jump or leap. I need to retain the services of an eye surgeon who reviews your eye and all the medical records and then makes a determination that there was negligence or that that the cataract, the lens they were attempting to use was defective. Assuming it's still available for somebody to look at, because I would assume when you went back in for the subsequent surgery, they replaced that lens. But in any event, all of this requires expert testimony, and you have 2 years in Pennsylvania to bring such a claim. You're 3 months into that 2-year period. If you want to have your case looked at, you need to get with an attorney, sign up with an attorney, have that attorney request your medical records, put all the potential people on notice, and then have those medical records examined by an expert who would have to conclude that you are correct, Earl, and that you were the victim of malpractice. And so it's complicated. It takes time. You should associate with an attorney immediately. Feel free to give us a call, 215-227-2727 after we're off the air. And we can have your case reviewed. But you by yourself, and even when your subsequent doctor, and I love this, the subsequent doctor goes, yeah, that first doctor committed malpractice. But they're not the ones who are going to come in and testify at court and be your expert. So you have to get with an attorney who will get a legal expert in the medical field who will testify on your behalf. Earl, I hope I helped you out. If you really want to see if you can pursue this, you got to give us a call after we're off the air.
Okay, I just want to say one other thing. 2 other surgeons looked at it.
Unfortunately, you can't. And we're going to have to leave that as a...
never know.
Yeah, because we're out of time. Folks, we're gone. We'll see you next Saturday. Same time, same place. Thank you, David.
Thank you.
YouTube.
We're back on YouTube.
The after show.
We're never off of YouTube. This is the after show.
It's a wonderful thing.
Yes.
All right, get out the cards, the dice. Let's go.
I'm going to play some poker tonight at my party, I think. You know, there's going to be a number.
Texas?
Texas.
Okay.
Texas. Yeah.
What's the
I'm going down to Esposito's to pick up the 50-pound roast pig.
Look at the face.
I got sharp provolone and long hots. I'm going to kill it.
Do I want to get in this game? How much does it cost to get in this game?
If we play, a couple $100. Couple hundred.
I got a couple of $100.
I'm a
Some of your wealthy friends?
You could be my partner.
Some of your
we
wealthy
could we
friends?
could we could go we could go partners.
Can we take some people down?
Yeah, we could take the whole table down. Yeah.
Dak, you should come through today.
I think
I might come through, but I can't.
Go in there like Matt Damon and
I ain't got
Ed
no-
Norton. And you ever see that movie? Rounders? The
no,
best
Rounders.
all professional card players. It's the most accurate
on
movie about poker ever.
I may have seen it, but I immediately forget every movie I ever see.
You love
I flush it out like
No,
it's
if
a
you're
law
poker
school
player,
exam.
If you're a poker player, you'll love it.
I'm gonna rewatch it then.
Rounders.
Okay. And then the other thing is when I rewatch a movie that I had watched, it's as if I never watched it. So it's a whole new experience
You
again.
don't wear a hat. See if you want. There's not a photo anywhere. An Eagles hat, a Phillies hat.
Right.
Nothing?
Well, tonight if you come to the party, I'm gonna wear a hat.
What kind of hat?
I don't know yet, but it's gonna be a special one. I got this.
Oh, your yarmulke? That doesn't count.
No Yamahas.
Doesn't count.
No Yamaha. I got this Louis Vuitton hat
Yamahas?
that I bought, and I even have it in a hat
Oh,
box.
yeah.
It's wait a minute.
What type of hat is it?
I can't tell you because if you got to come tonight, you'll see it.
What do you think?
I'm intrigued.
What time is this
Text
party
the
starting?
address again.
6, and it's 6. Okay, so don't go rolling in at 8 and do one of your Manny Manuel things.
Fashionably late.
No, 5:55. I want to see your black ass at my door.
Black ass.
Come on.
Listen, you little Jew.
Good night.
We just
that's
we
over.
love each
Cut the
other.
feed.
It's all
Cut
love.
the
We'll see you next week, but right here, same time, same place.
I forgot your address. I mean, text it to me.
Yeah,